Okay, part two. Sorry about that. I didn't know it was going to take that long. I'm going to try to finish up here. Anyways, these are the different kinds of entries. This is the entry book. Oh, the entry book. I heard about this in the UK. According to the entry book, that is your mother's signature. Just happened to be a forgery in the entry book. Long story. A brief description of the premise in the entry book. So that would be the first place it went in. When it goes in, it first goes into the entry book. And from there, they get a grantor's index. Right? So they're going to take the grantor's name, a grantee's index by the grantee, an index to each book of record, in which shall be entered in alphabetical order, the name of each grantor and grantee, the page at which the instrument is recorded. When required by the court board, an abstract book, which will show tracts of every conveyance or encumbrances recorded. An index to record maps, plats, subdivisions. Such index to be made by description of land mapped or subdivided by range, township, section, quarter section, etc. All these different indexes will lead you to the owner's certificate of title. An index showing the alphabetical order of the names of parties against whom judgments have been rendered or made, and transcripts of memoranda of such judgments have been recorded. They have a judgment book there someplace. And we need to read this. Here's a long-ass name for an act. An act concerning constructive notice of condemnation proceedings to sell real property of decedents, to pay debts, or other suits seeking equitable relief involving real property, and proceeding in bankruptcy. And they have us in bankruptcy because nobody's paid the local taxes. You're always paying your... Right? If you need to pay your 2011 taxes in 2011 and you don't, they're going to put a lien against your property and go sell the bond. If you haven't redeemed it within 1 year, well, they're just going to go ahead and have a tax sale on your property. An index of all ordinances, petitions, assessment rolls, orders, judgments, and other documents filed or recorded. And all this is public record. They have to let you see it. Name and address of grantee and grantee or grantees. No deed or other instrument which transfers title of real property may be recorded unless and until the name and address of the grantee or grantees appears on its face. What address? What name? How do they put your name in these things when you look them up online? They got grantor and grantee. It's last name first, first and second. That's how the grantees and grantors are listed in the search pages by last name. Real estate index number. May establish a permanent real estate index number system which shall describe all real estate in the county. By township, section, block, parcel, or lot, the street or post office address. Didn't say your address, it said the post office address. What is the post office's address? Rockford, Michigan 49341. Is that the address? 49341 is that the address? By township, section, block, parcel, or lot, the street or post office address could be either or. We need to get them to be the same so the mail gets to us, if any, and street code number, if any, of such real estate. Alright, so they could be using the block, the lot number as the address. Lot 160, subdivision. Alright, that's not a street code number. What's a street code number? 10955, 14 Mile Road. Sounds like a street code number. Such index number system may be used by the Supervisor Assessments Board of Assessors, and the case may be in counties less than 1 million for purposes of assessment and collection of taxes. The recorder having established such index number system shall be the sole authority in the county to designate and assign index numbers and may establish and maintain cross indexes of numbers assigned to complete legal descriptions of the real estate to which the numbers relate. There's supposed to be a number that relates to your complete legal description of the real estate. And legal description is on your warranty deed. All indexes established hereunder shall be open to the public inspection and shall be made available for public during regular business hours. You're supposed to have free access. It's like, it should be like walking into the library and looking at the books. What else we got here? Deeds of sheriffs. Deeds and other instruments affecting real estate made by sheriff, executor, administrator, guardian, trustee, or other persons affecting behalf of others shall be indexed in the name of the person whose lands is sold or affected as grantor. And note shall be made in index indicating the capacity the deed was made. And this isn't the place where the deeds are now. If the recorder should willfully fail to perform any duty imposed upon him by this division, he shall be guilty of malfeasance in office, and shall be punished accordingly, and shall be liable to the party injured for all damage occasioned thereby. Now, by this division. Now, I don't know what they mean by this division. I have to find that out. This is cool. Ancient records. All copies and transcripts of ancient books, records, and papers bearing the date prior to the 13th of July in the year of our Lord, 1787. Now in the office of the recorder of the county of Randolph. Right? You want to find the old stuff, you need to go to the county of Randolph. They got stuff from before 1787 there. There wasn't anybody in Illinois in 1787. There's frickin' trees and mosquitoes. Records open to inspection. All records, indices, abstracts, and other books kept in the office of any recorder, and all instruments filed therein, and all instruments deposited or left for recordation therein shall, during the office hours, be open to public inspection and examination, and all persons have free access for inspection, examination to such records, indices, books, instruments, which the recorder shall be bound to exhibit to those who wish to inspect or examine the same, and all persons shall have the right to take memoranda and abstract thereof without fee or reward. This section is subject to the provisions of the Local Recorders Act. Got to look at that one. The Local Recorders Act. Public Act 86-962. So, if these people don't want to do what they're doing, and it says that they're supposed to, what Roe found out is when they had a question about her getting her copy of the certificate of tax sale, they said, well, we can't give that to you. You're not the purchaser. He said, well, I could fill out a FOIA. They said, well, just a minute. And they ended up calling the state attorney, they call it there, which is probably the county attorney, because he's sitting in the county building in an office called the state's attorney. And they said, yep, give it to her. And she talked to him a little bit more. They said, well, we actually work for the assistant to the state's attorney. And again, the assistant to me, especially as chief assistant, is really the power player. The inspected guys are all in the de facto. Anybody who's elected is in the de facto. Judgment documents. In all counties where recorder is elected, in which the recorder has therefore been or shall thereafter be required by a county board to keep abstract books showing tract of every conveyance or encumbrance is recorded. Such recorder shall and is hereby authorized to keep judgment dockets indexed thereto, showing judicial proceedings affecting title to real estate in such county, tax sale books with indexes showing sales and forfeitures of land for unpaid taxes and assessments, and other such books as are usual or necessary to be kept for the purpose of making complete abstracts of title to real estate They got the judgment dockets by tract, and we saw that tract was township. What is it? Township, section, range, subdivision, block, lot, in that particular order. Provided that nothing in this division shall be construed to empower the recorder to prevent the public from examining or taking memorandum for the records or instruments filed for record, indexes, or other books in his official custody, but it shall be his duty at all times when his office is or is required by law to be open to allow all persons without fee or reward to examine and take memorandum from the same. This section is subject to provisions of Local Recorders Act. That would be 55 ILCS 5/3 5038. They won't let you see it. Say, I want to file a complaint against this office. Give me a form. So that was all about the recorder. Now here's the clerk. Yeah, what did we have on the clerk that was really of interest? It was really a bunch of the same stuff. Oh, office and quarters. The county clerks will keep his office at the courthouse of his county. He shall be the keeper of the seal of the county, which shall be used by him in all cases where he is required to use an official seal. Now, here's the goofy thing. All these elected people and so forth. It turns out that where Roe is in Kane County, it looks like the circuit court clerk is the one who has been designated to be the lowercase county clerk. As well as the circuit court clerk. And it's just because of some paperwork we had found from his predecessor where it was her name down there as county clerk at the same time she was the clerk of the court of record in the county. Whenever a vacancy occurs in the office of the county clerk or in any county, including counties' populations less than 60 million inhabitants, the chief deputy clerk shall perform all duties appertaining to the office of the county clerk. Chief deputy. There they are again. Frickin' chief deputy. The election code by appointment of a clerk pro tempore, who shall qualify by giving bond and taking oath as required of the county clerk, and shall thereupon perform all duties entitled to amulets and subject to the penalties pertaining to the office of the county clerk. They can appoint a clerk pro temp, provided in that in case the county clerk is called into the active military service in the United States, the appointee shall perform and discharge all duties of the county clerk during the time such county clerk is in active duty service in the United States. And by God, there's a war flag sitting outside the building. They're on active duty. That the office of county clerk shall not be deemed vacant during the time the said county clerk is in active duty service of the United States. Custody of records, public inspection. The county clerk shall have care and custody of all records, books, and papers appertaining to and filed or deposited in their respective offices. And the same, except as otherwise provided in Vital Records Act, shall be open to the inspection of all persons without reward. Alright, we just need to go look in these other offices for things not necessarily against our name, against our property. That's what they're after. They're after the property. They're putting a lien against your property. File and preserve all bills of account acted upon by the board, and when an account is allowed or disallowed, he shall note the fact thereon, and when part of any account is allowed, he shall note particularly the items allowed. Date and amount of each order upon the county treasurer, and the name of the person in whose favor the same is drawn. Before any such order is delivered to the person for whose benefit it is drawn, the county clerk shall present the same to the county treasurer, who shall personally countersign the same. To keep a book in which shall be entered in alphabetical order by name of the principal a minute of all official bonds filed in his office, giving the name of the office, the amount and date of the bond, the name of the sureties, the date of filing, with such reference to the number or other designation of the bond that the same may be easily found. So they got a bond book someplace by the name of the principal in alphabetical order. It's going to list all the bonds and the amounts and the sureties and when it was filed and reference number to other designations of the bond that may be easily found. All right. Anywho, all that from this. So again, this is the Torrens Registry Act, or actually for land registration in Illinois. All states have some kind of land registration or land recordation, whatever it is, but it's not that Register of Deeds office or wherever you're going to now that your paperwork is at. That is the incorrect office, or it's on the wrong side of the door of that office. You were supposed to take your copy and after the initial registration, which was done, could have been 100 years ago, transfers of registered land are made in the following manner. The owner executes the usual warranty deed and submits it together with his certificate of title to the buyer. We saw the deed, we didn't see a certificate of title. In every transaction, the owner must produce his duplicate certificate of title. He can do absolutely nothing without it. You must get yours now that you're the owner. If lost or destroyed, upon proper showing, the owner receives a certified copy marked Owner's Certified Copy. So this owner certificate of title is much the same as the certificate of title or the certificate of live birth. That's your certificate of title for your body. We're going to find out we put this stuff in the same office also. Okay. This, after entry of transaction upon the original certificate of title, answers the same purpose of law certificate. No new forensic conveyances are required. The buyer, after inspection of the original certificate of title, you want to go inspect the original certificate of title in the registrar's office, and finding thereon no encumbrances or liens, or if you do, go find the liens and make sure that they're taken off. All the ones back from the very first time it was ever put on with the original registration. Some $2 tax or who knows what it is. Safely pays over to the purchase money and receives the deed and duplicate certificate of title. He then delivers them both to the registrar, who, when satisfied as the identity of the parties that the transfer should be made, notes the transfer upon the register. This operates to transfer the title. No title passes by delivery of the deed. No title passes by delivery of the deed. The deed after delivery and before the registration of the transfer is a mere contract between the parties. It's nothing but a purchase agreement. Its sole object is to authorize the registrar to register the transfer. The transfer is registered when the registrar cancels the old certificate of title that has the grantee's name on it and issues a new one in duplicate as before, one called the original, being retained by the register, and the other the duplicate, also known as the owner's certificate of title. After proper receipt thereof, filed with the registrar, delivered to the buyer, now the new owner. The deed is kept by the registrar. Got to take your warranty deed from where it is now to the county clerk and tell him you want to inspect the original certificate of title that's on there now, and it's probably, again, it's going to be in the name of the grantor, because you've never done this, so it doesn't show you being the owner. still shows the grantor being the owner. Look on it. Everything that's written, every indication, anything. What are these? Bring me the records, please. Take care of all the liens and encumbrances. Go pay your taxes at the general tax window in the same year they're due. Don't go to the property tax window. Go to the general tax window. Pay the general taxes. Keep the tax liens off you. And soon we'll figure out what the address is we need to change it to, so the mail comes to us instead of going to the lost mail department. And then we'll see what the world looks like. So, alright, that's enough for me. Thanks for listening. We'll see ya.